Avani Shija Aji, student ID number 220732889. Today I am going to say about the carrier's duties and liabilities under the Hague rules, Hague Visby rules, Hamburg rule, and Rotterdam rules. There are certain rules and immunities of carriers under these rules. The fundamental aspect of international maritime law that govern the responsibilities and liabilities of carriers when transporting goods by sea. Visby rules have some duties that have imposed implications on carriers regarding the care and handling of goods during the transportation by sea. It sets standards for the carrier's responsibility concerning the proper packing, handling, and transportation of goods. Liabilities under the Hague Visby rule are carriers have limited liabilities of certain types of losses or damage to carrier unless negligence or fault can be proven. The Hague Visby also outlines specific exceptions where the carriers is not liable, such as inherited ways of nature, where the immunities of Hague Visby rules provide certain immunities of carriers in case involved cargo transportation of sea. These immunities often cover carriers' liabilities in specific situations, such as for act or omission or done to properly care of the cargo or due to inherent nature of or rise of goods. The rules aim to balance responsibilities between the carriers and cargo owners in the maritime transport. The Hamburger rules have some duties similar to the Hague Visby rules, and the Hamburger rules emphasize the carrier's duty to properly handle and cargo for the care for the cargo. They also place emphasis on the documentation and information provided to the shippers. When come to the liabilities of Hamburger rules, they have slightly different from the Hague Visby rules. Generally, expand the carrier's liabilities compared to the Hague Visby rules, making carrier liable for the broader scope of damage. The burden of proof shift to the carrier to show they have take necessary measurement to prevent the damage. The immunities come to the hamburger where like an alternative to the Hague Visby rules provide similar but slightly different immunities for carriers in maritime transport. They cover the carrier's limitations of liabilities in certain situations, such as when loss or damage is caused by circumstance outside the uh, ca- carries control or inherent nature of goods or due to an act of war. The Hamburger rule aimed to establish a more balanced framework for carrying liabilities and problematic cargo owners in the transportation of maritime. And when come to the Rotterdam rules, the Rotterdam rules introduce a broader scope of responsibilities for carriers, shippers, and other parties involved in the transportation process. They emphasize cooperation between parties and the provisions of accurate information. Liabilities. When it comes to the liabilities, the Rotterdam rulers maintain a balanced approach between the interest of carriers and the shippers, aim to create a more uniform and predictable liability regime. They extend the carrier's liability while providing the clear use of damage. When come to the immunities, it says to be that it's mainly known as a UN Convention and Contract for international carriage of goods and wholly or partly by sea in in a more recent international treaty governing maritime transport. The rules expand on the carrier's responsibilities and liabilities compared to the previous conventions. They aim to enhance different international and the compare framework to the multimode transport. When it comes to the some point, the ratification and uniform adoption. One of the significant challenge is achieving widespread ratification by and uniform adaptation of these conventions across the different jurisdictions. The maritime industries involved numerical countries with diverse legal system, making it challenging to secure the universal aspect and transport on door-to-door liability. The Rotterdam rules introduce provisions for multi-mode transport and extend liability to entire door-to-door transport and border scope presents challenges in coordinating and regulating the responsibilities and various acts. The technical and the electronical documentation challenges. The Rotterdam Rule emphasized the role of electronical document in maritime transportation. The widespread adoption of electronical documentation faces challenges related to the technological infrastructure and data structure and the need for a global framework for electronical transaction and economical consideration industrial assistance. The ship industry may resist change the potential increase liability or operation cost. Some stakeholders may hesitate to adopt new convention that could impact their establishment and practice and economic interest. Inter, and the geopolitical and cultural difference. The geopolitical consideration and cultural difference can imply the uniform acceptance of international convention. Countries which diverse legal tradition and economic interest may have various perspective on the need or implications of the rule. Implications of the rules. Implications of the rules. Here there are the two potential research questions I have added in the poster, where what are the difference between the Hamburg, Rotterdam, and Hague Visby Rule and regarding carriers liabilities and immunities. The question is trying to develop the specific provisions of each convention regarding the carriers liabilities, exceptions, and immunities, which already I mentioned before, that it seeks to identify and convey the notions or in liability framework across these rules and assess these implication for carriers and shippers in terms of risks, allocations, and legal protections. What prospect and different difficulties to the Rotterdam rule offer to updating the international maritime framework. These were evaluating the Rotterdam rule's potential to addressing the contemporary challenge in the maritime trade, such as technical advancement, sustainability concern, and evolving trade practice. It aimed to explore the extent to which these rules are accommodation modern need while also examining the obstacles in their implications and potential benefit for the industry. These research questions have to avenue to the investigate the specification of each convention and the practical implication in the contemporary maritime trading, provide insight into legal framing, challenge and opportunities for improving the research and concerning Hague, Visby, Hamburger, and Rotterdam might focus on various aspects with the realm of maritime and international trade here. Trade when it comes to the comparative analysis to critically analyze or compare with the three rules in terms of legal implications, scope, liability, and immunity for carriers, shippers. The conduct through examination of provisions in each convention, analyze the similarity, difference, strength, and weaknesses. What are the impacts on the international trade, where these international trade practice, commerce, and shipping industry gather empirical data and case studies to evaluate how these conventions are influence and trade patterns, shipping cost, legal dispute, and the relationship between the carriers and shippers. To identify and analyze the legal system or the rules that provide, it need to collect through the interview, survey, or case study under the challenges faced by the stakeholders. To investigate the Hague, Visby, and Hamburger, and Rotterdam in addressing contemporary maritime challenges such as advancement or the trade, the maritime practice where according to these rules, it says about the carriers rules and liabilities and what are the implications that going to bring on the maritime law, and what are the certain uh, applications that get in the industries for the uh, three Hague Visby or Hamburger and Rotterdam rule. Um, while each set of rules aim to regulate the responsibilities and immunities of carriers in the maritime transport of goods, they differ in their approach to modernizing liabilities, burden of proof, and the scope of obligations. The Hague Visby Rule set a benchmark that the Hamburger introduced more stringent carrier responsibilities, and Rotterdam Rule extend the scope of liabilities. Each reflect the distinct shift in legal approach to the maritime commerce.